Hello everyone. Today let us start with our topic of discussion, that is the plaint. We have seen in the pleadings that the pleadings of the plaintiff is the plaint and the pleadings of the defendant is the written statement. Okay. Now today we are going to discuss order 7 of the Civil Procedure Code, which describes what are the particulars which are needed to be incorporated in the plaint. First of all, we know that the suit is commenced by a plaint. So what is a suit? While defining, there is no definition in the Civil Procedure Code. There is no definition of the plaint also in the Civil Procedure Code, but there is a description of what should be there in the plaint. From that we come to know that the plaint has to show all the important things which the plaintiff wants to prove before the court. If he leaves out, as we said in the pleadings, both the plaintiff or the defendant, if they leave out any remedies, if they leave out any kind of reliefs which they wish to ask before the court, it is deemed that they have relinquished it, so they cannot ask for it. So that is why we can say that plaint is the most important document, the most important thing which we file before the court, because that is the basis of our suit. So when a suit is filed, the basis of a suit has to be strong, so that the plaintiff is able to get his remedies before the court. So then let us see what are the provisions of order 7. We will see all the contents of the plaint and we will discuss them in detail. First of all, when we speak about the plaint, we can define the plaint in a short sentence, that is, it is a statement of claim, a document by presentation of which the suit is instituted. This is a simple definition. So we file the plaint and the suit is instituted. That is, we set the civil law in motion, let us say. Okay, just like by filing the complaint in the criminal proceeding, it is we just institute the criminal proceeding and we start the law in motion. So in the same way here also, the plaint is a document which we present and we institute the suit. Now what is the object of the plaint is? Only the object is very clear, that is to state the grounds upon which the assistance of the court is sought by the plaintiff. Plaintiff has his rights. Plaintiff has his remedies which he wants to claim under the law. So there is a law where it gives him a remedy. So to ask for that remedy, he needs the help of the court. So he approaches the court, states the ground, and on those grounds the court decides whether the law is applicable in this matter and whether the reliefs can be given to him. So to state the grounds, he needs this particular document, that is the plaint. So whatever comes before the court has to be later on proved by help of evidence. So this object has to be served. So that is why, looking at this object, we have to see what are the particulars which has to be given in the plaint. Now rule 1. First of all, rule 1 lists all the following particulars which we have to file, all the particulars which are there to be stated before the court. See, first of all, when you look at a plaint, we see that it starts with the name of the court in which the suit is brought. So it is called as a cause title. So in any plaint, there is a cause title where it shows in the name of the court in which the suit is brought, means in the court of the second civil judge, junior division or senior division, at so and so place. You will give the place. So that name has to be it is a thing which has to be there in the plaint. Second, then comes the description of the parties. What are the descriptions of the parties? First is the plaintiff files. So his name, his description, whose son, or if he is working and if he wants to do his work, then that description, and a place of residence of the plaintiff at present where he is residing, in detail that has to be given. A name and description includes his age also, to show that he is a minor or major. Okay, so that is the second thing. Then after that, versus defendants. So who is the defendant that he wishes to include? If it is 1 or 2, the name, description and place of residence of the defendant as far as can be ascertained, it says. So as far as he knows about the address of that defendant, he can add it in the plaint. Then where the plaint or defendant is a minor, suppose the plaint is a minor or a defendant is a minor, then there is a provision in the CPC that he can be represented by his next friend. Next friend means it's a name. Next friend means a person who stands before the court and represents him. That person will be a major, of course. So if he is a minor, then a person or if he is a person of unsound mind, then he cannot represent himself because he is not able to understand what to say or what to represent. So a person has to be in his place. So there what happens, to represent him, again another person also will be shown as his next friend. So represented by his next friend. So when the plaintiff or defendant is a minor or a person of unsound mind, a statement will be given. So A being a minor, aged of so many years, then represented by his next friend so and so. So that will be the next thing. Then the facts constituting the cause of action and when it arose. Then it comes to the facts. When we then we have see, the format is that a plaint filed, the format is already given in the CPC itself, format of the plaint and the format of the written statement. So what are the other things which are essentials? Essentials are, see, first is the whatever facts constitute the cause of action. So what is the reason why you are coming before the court, and when that cause of action arose. Then the facts showing that the court has jurisdiction. You have to mention that as this case has arisen in this particular place, or see, when we have seen the provisions relating to jurisdiction. So what are the facts which has brought you to this court? So that is the fact which shows that the court has jurisdiction. So you say that the court has jurisdiction in this matter. Then the relief which the plaint claims, the last one is the relief. What is the thing which he wants from the court? So you need to express, and you need to state that this is the thing which I want the court to help me in. So this is the relief which I want. So that plaintiff has to state the relief in clear words. Then if the plaintiff has allowed a set off, suppose he is having a dues, he has to be given some money, or he is due to be paid that amount from the defendant, and therefore he has applied here to the court, and he says that I will set off a particular part of my claim. Or if he relinquishes a portion of his claim, then the amount so allowed or the amount which is relinquished has to be stated clearly. Then the plaint should also consist of a statement of the value of the subject matter of the suit, because you know that every court has a pecuniary jurisdiction. So to decide the pecuniary jurisdiction and the court fees, see, there are two things. When you I'm sorry, just a moment. When you value the suit, the value is for the purpose of bringing that suit under that court's jurisdiction, number one, and on that value you pay the court fees to the court. So for that purpose the statement of the value is to be given. ಈ ಪ್ಲೇಂಟ್ ನಲ್ಲಿ, ಪ್ಲೇಂಟ್ ಅಂದರೆ ಒಂದು ವಾದಪತ್ರ, ಪ್ಲೇಂಟಿಫ್ ಒಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಸಲ್ಲಿಸಿದಾಗ, ಒಂದು ದಾವೆಯನ್ನು ಹೂಡಿದಾಗ ಒಂದು ಮೊದಲನೇ ಹೆಜ್ಜೆ ಅಂದರೆ ವಾದಪತ್ರನ ಫೈಲ್ ಮಾಡೋದು. ವಾದಪತ್ರದಲ್ಲಿ ಏನೇನು ಇರಬೇಕು, ಏನೇನು ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಇರಬೇಕು, ಅದನ್ನು ನಾವು ರೂಲ್ 1 ಆರ್ಡರ್ 7 ಅಲ್ಲಿ ನೋಡ್ತೀವಿ. ಸೊ ಆದೇಶ 7 ನಿಯಮ 1 ಏನು ಹೇಳುತ್ತೆ? ಮೊದಲನೇದಾಗಿ ಕೋರ್ಟಿನ ಹೆಸರು ಇರಬೇಕು, ಯಾವ ಕೋರ್ಟಲ್ಲಿ ಈ ಪ್ಲೇಂಟನ್ನು ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಎರಡನೇದಾಗಿ ಆ ಪ್ಲೇಂಟಿಫ್ ವಾದಿಯವರ ಹೆಸರು, ಅವನ ವಿವರ ಮತ್ತು ಅವನು ಇರುವಂಥ ವಾಸಸ್ಥಳ ಅದನ್ನು ಬರೀಬೇಕು. ಮೂರನೇದಾಗಿ ಡಿಫೆಂಡೆಂಟ್ ಯಾರು ವಿರುದ್ಧವಾಗಿ ಕೇಸ್ ಹಾಕ್ತಾರೆ ಆ ಪ್ರತಿವಾದಿಯ ವಿವರ, ಪ್ರತಿವಾದಿಯ ಇರುವಂಥ ವಾಸಸ್ಥಳ ಎಷ್ಟು ಮಟ್ಟಿಗೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ ಅಷ್ಟು ಮಟ್ಟಿಗೆ ಈ ವಾಸಸ್ಥಳ ಅಂತ ಹೇಳ್ಬೋದು. ದೆನ್ ಡಿಫೆಂಡೆಂಟ್ ಅಥವಾ ಪ್ಲೇಂಟಿಫ್ ಅಲ್ಪವಯನ ಇದ್ದರೆ ಅಥವಾ ಅವನು ಮಾನಸಿಕ ಅಸ್ವಸ್ಥನಾಗಿದ್ದರೆ ಅವನ ಅದಕ್ಕೆ ಪರವಾಗಿ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಬೇಕು. ಈ ಸ್ಟೇಟ್ಮೆಂಟ್, ಈ ಹೇಳಿಕೆಯಿಂದ, ಅಂದರೆ ಇಷ್ಟು ವಯಸ್ಸಾಗಿದೆ ಅಂತ ಹೇಳಿ. ದೆನ್ ಯಾವ ಸಂಗತಿಯಿಂದ ಈ ವ್ಯಾಜ್ಯದ ಕಾರಣ ಉಂಟಾಗಿದೆ ಆ್ಯಂಡ್ ಮತ್ತು ಯಾವ ಸಮಯದಲ್ಲಿ ಉಂಟಾಗಿದೆ ಅದು ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆ, ಅದು ಹೇಳಬೇಕು. ನೆಕ್ಸ್ಟ್, ಈ ಕೋರ್ಟ್ಗೆ ನಾವು ಯಾವ ನ್ಯಾಯಾಲಯ ಮುಂದೆ ಬಂದಿದ್ದೀವಿ ಆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಈ ಮ್ಯಾಟರ್ ಟ್ರೈ ಮಾಡೋಕ್ಕೆ, ಇದನ್ನು ಮುಂದೆ ಅಧಿವಿಚಾರಣೆ ಮಾಡೋಕ್ಕೆ ಇದು ಅಧಿಕಾರ ಇದೆ ಅಂತ ತೋರಿಸೋಕ್ಕೆ ಅವರ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿಯನ್ನು ಹೇಳಬೇಕು. ಅದಾದ ಮೇಲೆ ರಿಲೀಫ್ ವಿಚ್ ದ ಪ್ಲೇಂಟಿಫ್ ಕ್ಲೇಮ್ಸ್, ಯಾವ ಪರಿಹಾರ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಆ ಪರಿಹಾರನ ಸ್ಪಷ್ಟ ಶಬ್ದದಲ್ಲಿ ಸ್ಪಷ್ಟ ಪದಗಳಲ್ಲಿ ವಿವರಿಸಬೇಕು, ಹೇಳಬೇಕು, ಕ್ಲೇಮ್ ಮಾಡಬೇಕು. ಅದಾದ ಮೇಲೆ ಅವನ ಅಮೌಂಟ್ ಏನಾದರೂ ಕೊಡಬೇಕಾದ್ರೆ, ಸಾಲ ಏನಾದರೂ ಇದ್ದರೆ ಆ ಸಾಲದಲ್ಲಿ ಯಾವುದೇ ಇದನ್ನು ವಜಾವಟ್ಟು ಮಾಡ್ತಾ ಇದ್ರೆ, ಅವನ ಬಿಟ್ಟು ಕೊಡ್ತಾ ಇದ್ರೆ ಎಷ್ಟು ಅಮೌಂಟ್ ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಅದನ್ನು ಕ್ಲಿಯರ್ಲಿ ಪ್ಲೇಂಟಲ್ಲಿ ಇರಬೇಕು. ಅದಾದರೆ ಈ ಸೂಟ್ ಫೈಲ್ ಮಾಡೋದ್ರಲ್ಲಿ ಒಂದು ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಅದನ್ನು ಒಂದು ಮೌಲ್ಯಮಾಪನ ಹೇಳಬೇಕು. ಮೌಲ್ಯಮಾಪನ ಯಾವುದಕ್ಕೆ ಏನಕ್ಕೋಸ್ಕರ ಮಾಡ್ತೀವಿ ಅಂದರೆ ಈ ಕೋರ್ಟಿನ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿ ಡಿಸೈಡ್ ಮಾಡೋಕ್ಕೆ, ಮತ್ತು ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟೋಕ್ಕೋಸ್ಕರ ಈ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿ ಡಿಸೈಡ್ ಮಾಡಿ ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟೋದಕ್ಕೆ ಆ ಮೌಲ್ಯಮಾಪನ ನಾವು ತೋರಿಸಬೇಕಾಗಿದೆ. ನೆಕ್ಸ್ಟ್, ಇದು ಜನರಲ್ ಸಾಮಾನ್ಯವಾಗಿ ಎಲ್ಲ ನಿಯಮಗಳು ಅಂತ ಹೇಳಿದ್ವಿ ರೂಲ್ 1 These are the general things. In rule 2, in money suits, see we are coming to different suits or different kinds of suits. So rule 2 speaks about when plaintiff seeks recovery of money. ಈಗ ದುಡ್ಡಿನ ರಿಕವರಿ ಕೇಳ್ತಾ ಇದ್ರೆ, ದುಡ್ಡಿನ ರಿಕವರಿ ಕೇಳುವಾಗ ಪ್ಲೇಂಟಲ್ಲಿ ಏನಿರಬೇಕು ಅಂದರೆ, when plaint seeks seek recovery of money, the plaint shall state the precise amount claimed. Precise amount, ನಿಶ್ಚಿತ ಅಮೌಂಟಿಗೆ ಹೇಳಬೇಕು. ನನಗೆ ಸ್ವಲ್ಪ ದುಡ್ಡು ಬರಬೇಕಾಗಿದೆ, ಐ ನೀಡ್ ಟು ರಿಕವರ್ ಸಮ್ ಮನಿ, ಆರ್ ಎ ಮನಿ ಆಫ್ ಐ ನೀಡ್ ಟು ಸೀಕ್ ದ ಸಮ್ ಅಮೌಂಟ್, ಆರ್ ದಿಸ್ ಇಸ್ ದ ಅಮೌಂಟ್ ಡ್ಯೂ ಅಂತ ಹೇಳುವಾಗ ವಾಟ್ ಈಸ್ ದಟ್ ಅಮೌಂಟ್, ಪ್ರಿಸೈಸ್ ಅಮೌಂಟ್ ಇನ್ ವರ್ಡ್ಸ್ ಆ್ಯಂಡ್ ಇನ್ figures. We have already spoken about that when we discussed pleadings. Then suppose the amount cannot be precisely claimed. There are so many things. For example, mean profits keltira. So when you are asking for mean profits or for an amount which is due to him on taking unsettled accounts between him and the defense, the accounts are not settled, so there may be interest on that and this may be growing. Okay, then the mean profits also, that is something which the defendant has to pay to him because of him being in wrongful possession of that property. In such cases, mean profits cannot be precisely stated. It has to be discussed and it has to be calculated at the time of the recovery of the money. So in such cases, or when movables are there in possession of the defendant, suppose he is having your movables in possession, then the plaintiff can only approximately state the value of the movables. Then if the debts he cannot estimate even with reasonable diligence, the whatever value of the debts are there, whatever he has to pay him, suppose the plaintiff is not able to find out exactly the amount what is to be paid by the defendant and he cannot estimate that, then he can approximately, in these 3 cases, mean profits, movables and debts which he cannot estimate, he can approximately state the value or amount which he has sued. So approximately it comes to this amount, he has to state that amount. Okay, then when the suit is for immobile property, ಎರಡನೇದಾಗಿ ಮನಿ ಸೂಟ್ಸ್ ಇರುವಾಗ, ಒಂದು ದುಡ್ಡಿನ ರಿಕವರಿ ಮಾಡುವಾಗ ಮಧ್ಯಾವಧಿ ಲಾಭಗಳು ಇದ್ದರೆ ಅಥವಾ ಡಿಫೆಂಡೆಂಟ್ ಪೊಸೆಷನಲ್ಲಿ ಸ್ವಾಧೀನತೆಯಲ್ಲಿ ಒಂದು ಚಲ ಪ್ರಾಪರ್ಟಿ ಇದ್ದರೆ, ಚಲ ಸೊತ್ತು ಇದ್ದರೆ, ಮತ್ತು ಆ ಸಾಲವನ್ನು ಅವನು ಸರಿಯಾಗಿ ಅವನು ಎಷ್ಟು ಕಾಳಜಿಯಿಂದ ನೋಡಿದ್ರು ಅದನ್ನು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರು ಅವನಿಗೆ ಎಕ್ಸಾಕ್ಟ್ ಎಷ್ಟಿದೆ ಮೌಲ್ಯ ಅಂತ ಹೇಳೋಕ್ಕಾಗದೇ ಇದ್ದರೆ ಆವಾಗ ಒಂದು ಅಂದಾಜು ಅಮೌಂಟನ್ನು ಹೇಳಬೇಕಾಗುತ್ತೆ. ಇಮ್ಮೋಬಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂದರೆ ಏನು? Immobile property is a property which is defined under the Transfer of Property Act and also under several acts. Immovable. ಸೊ ಇಮ್ಮೂವಬಲ್ ಅಂದರೆ ಸ್ಥಿರ ಪ್ರಾಪರ್ಟಿ, ಸ್ಥಿರ ಸ್ವತ್ತು. ಸ್ಥಿರ ಸ್ವತ್ತು ಇರುವಾಗ ಇವಾಗ ಈ ಕೋರ್ಟಲ್ಲಿ ಬಂದಿರುವಂತಹ ದಾವೆ ಸ್ಥಿರ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಿರುವಂಥ ವಸ್ತು ವಿಷಯ ಇದ್ರೆ ಆಗ ಆ ಸ್ಥಿರ ಸ್ವತ್ತು ಎಲ್ಲಿದೆ ಅದರದ್ದು ವಿವರ ಹೇಗಿರಬೇಕು ಅಂದರೆ ಆ ಸ್ಥಿರ ಸ್ವತ್ತು ಐಡೆಂಟಿಫೈ ಮಾಡೋಕ್ಕೆ ಅಥವಾ ಅದ್ರ ಬಗ್ಗೆ ಒಂದು ಗುರುತು ಹಿಡ್ಕೊಳ್ಳೋಕ್ಕೆ ಏನು ಬೇಕಾಗಿದೆ ಅದನ್ನ ಹೇಳಬೇಕು ಆ ಪ್ಲೇಂಟಲ್ಲಿ. ಸೊ ವೆನ್ ದ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ದ ಸೂಟ್ ಇಸ್ ಇಮ್ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ, ದ ಪ್ಲೇಂಟ್ ಶಾಲ್ ಕಂಟೈನ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ಇಸ್ ಸಫಿಷಿಯಂಟ್ ಟು ಐಡೆಂಟಿಫೈ ದಟ್ ಪ್ರಾಪರ್ಟಿ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, there is a schedule and which you say that this property number so and so according to the survey number, where it is identified by boundaries or numbers in the record of settlement or survey. So there is a record of settlement or survey where the survey numbers are given of that property. Then those boundaries should be stated. Those numbers of the survey numbers have to be stated. For example, the property to the west of this particular person's property. Then in the front of the property is the road. Right side is the field of Mr. B. Left side is the a road again, and behind that property there is any shop of so and so, whatever it is. You have to identify so that immediately that property, if you go to that place, you will be able to identify. So in such way the immobile property has to be described. ಇಂಥ ರೀತಿಯಿಂದ ಒಂದು ಸ್ಥಿರ ಸ್ವತ್ತನ್ನು ವಿವರ ಕೊಡಬೇಕು. ಇದಾದ ಮೇಲೆ ರಿಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಕ್ಯಾರೆಕ್ಟರಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದರೆ, ಪ್ರತಿನಿಧಿ ದಾವೆ ಇದ್ರೆ ಪ್ರತಿನಿಧಿ ಸ್ಥಾನದಲ್ಲಿ ವಾದಿ ಇದನ್ನ ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅಥವಾ ದಾವೆ ಹೂಡ್ತಾ ಇದ್ರೆ ಆಗ ಆ ವ್ಯಕ್ತಿ ಆ ದಾವೆನಲ್ಲಿ ಸ್ವಂತವಾಗಿ ಹಿತಾಸಕ್ತಿ ಹೊಂದಿರಬೇಕು ಅಂತ ನಾವು ಹೇಳಿದ್ವಿ. ಸೊ ಅವನ ಸ್ವಂತವಾಗಿ ಯಾವಾಗ ಅವನು ಇದನ್ನ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರಲ್ಲಿ ಅವನು ಹಿತಾಸಕ್ತಿ ಹೊಂದಿದ್ದಾನೆ, ಅವನು ಆ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡೋಕ್ಕೆ ಆ ಸೂಟ್ ಫೈಲ್ ಮಾಡೋದು ಮುಂಚೆ, ಆ ದಾವೆ ಫೈಲ್ ಮಾಡೋದು ಮುಂಚೆ ಏನೇನು ಕ್ರಮ ತಗೊಂಡಿದ್ದಾನೆ ಅದ್ರ ಬಗ್ಗೆ ಅವನ ಸೂಟ್ ಇದನ್ನ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾನ ಎಲ್ಲರಿಗೆ. ಸಿ ಇಟ್ ಇಸ್ ಎ ಇಂಪಾರ್ಟೆಂಟ್ ಥಿಂಗ್ ದಟ್ ಹಿ ಗಿವ್ಸ್ ನೋಟಿಸ್ ಟು ಆಲ್ ದ ಅದರ್ಸ್ ಇಫ್ ಹಿ ಈಸ್ ಇನ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಕ್ಯಾರೆಕ್ಟರ್. ಸೊ ವೆನ್ ಹಿ ಸೂಸ್ ಇನ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಕ್ಯಾರೆಕ್ಟರ್, what are the steps he has taken has to be stated in the plaint. He has taken these steps, he has given notice to these people, they are all under his representation, and it should show that he is having actual existing interest in that subject matter, because a representative character suit is a suit where the representative also has a interest. It is not a public interest litigation. It is a suit where along with his interest, the other's interest also he is representing. So he should show that in the plaint that I have actual existing interest in the subject matter. That is rule 4. ಸೊ ಅವನಿಗೆ ಸ್ವಂತವಾಗಿ ಹಿತಾಸಕ್ತಿ ಇದೆ ಅಂತ ತೋರಿಸ್ಬೇಕು. ರೂಲ್ 5 ಏನು ಹೇಳುತ್ತೆ, ರೂಲ್ 5ನೇ ನಿಯಮ ಏನು ಹೇಳುತ್ತಂದ್ರೆ, ದ ಡಿಫೆಂಡೆಂಟ್ ಆಲ್ಸೋ ಹ್ಯಾಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಇನ್ ದ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್, ಆರ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಕ್ಲೇಮ್ಸ್ ಟು ಬಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ದ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್. ಈ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ಗೆ ಅದರಲ್ಲಿ ಹಿತಾಸಕ್ತಿ ಇದ್ರೆ, ಪ್ರತಿವಾದಿಗೆ ಹಿತಾಸಕ್ತಿ ಇದ್ರೆ ಅದು ಹೇಳಬೇಕು, ಅಥವಾ ಅವನು ಹಿತಾಸಕ್ತಿ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಆದರೆ ಅವನು ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ. So the plaint will show that the defendant is claiming interest in the subject matter. That is to be stated in the plaint, and he is liable to be called upon to answer the plaintiff's demand. ತನ್ನ ಡಿಮಾಂಡನ್ನು ನಾನು ಡಿಮಾಂಡ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಈ ಡಿಮಾಂಡನ್ನು ಉತ್ತರ ಕೊಡೋಕ್ಕೆ ಅವನು ಹೊಣೆಗಾರ ಇದ್ದಾನೆ. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕ್ಲಿಯರ್ಲಿ ಸ್ಟೇಟೆಡ್ ದಟ್ ಹಿ ಈಸ್ ಲಯಬಲ್ ಟು ಬಿ ಕಾಲ್ಡ್ ಅಪಾನ್ ಟು ಆನ್ಸರ್ ದ ಪ್ಲೇಂಟಿಫ್ಸ್ ಡಿಮಾಂಡ್. ದಿಸ್ ಇಸ್ ರೂಲ್ 5. Okay, then coming to rule 6. Now suppose sometimes what happens is the plaintiff is not able to file the suit even when the limitation is running during the period of limitation. There is a limitation act under which there is a limitation for every kind of claim which you ask from the court, or for everything for which you approach the courts. So for that limitation you have to be clear that you have to, suppose you file in limitation, this is not required, but if you file beyond the law of limitation period, after the expiration of the period which is prescribed, then why that case was not filed within the limitation, on what ground he is claiming the exemption. Of course, the limitation law itself provides for section 5 where you can ask for condonation of delay of the period of limitation. You can ask for a condonation of delay. So ಈ ತಡ ಆಗಿದೆ, ಲಿಮಿಟೇಷನ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಕಾಲ ಪರಿಮಿತಿ ಸಮಯದಲ್ಲಿ ನಾನು ಫೈಲ್ ಮಾಡೋಕ್ಕಾಗಲಿಲ್ಲ, ಅದರಿಂದ ಯಾವ ಕಾರಣಕ್ಕೆ ನಾನು ಫೈಲ್ ಮಾಡೋಕ್ಕಾಗಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಆ ಗ್ರೌಂಡ್, ಆ ಆಧಾರ, ಯಾವ ಆಧಾರದ ಮೇಲೆ ಇವನು ಅದಕ್ಕೆ ಒಂದು ಎಕ್ಸೆಂಪ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾನೆ ಅದನ್ನು ಅವನು ಹೇಳಬೇಕು. ಅದಕ್ಕೆ ಒಂದು ಪ್ರಾವಿಸೋ ಸೇರಿಸಿದ್ದಾರೆ 1976 ಅಲ್ಲಿ. ಸಿ, in 1976 there was an amendment where they have added this proviso in rule 6. The court may permit the plaintiff to claim exemption from limitation on any ground not set out in the plaint if such ground is not inconsistent with the ground set out in the plaint. ಇದು ಏನು ಹೇಳುತ್ತಂದ್ರೆ, ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ನಾವು ಸುಮಾರು ಗ್ರೌಂಡ್ಸ್ ಹೇಳಿರ್ತೀವಿ, ನೀವು ಯಾವ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಕ್ಲೇಮ್ ಮಾಡ್ತಿದ್ದೀರಾ ಅಂತ ಎಲ್ಲ ಗ್ರೌಂಡ್ಸ್ ಹೇಳಿರ್ತೀವಿ. ಆದರೆ ಆ ಗ್ರೌಂಡ್ ಆಧಾರ ನಿಮ್ಮ ಲಿಮಿಟೇಷನ್ ಎಕ್ಸೆಂಪ್ಷನ್ ಕೇಳಕ್ಕೆ ಆಧಾರ ಇರೋದಿಲ್ಲ. ದರ್ ಇಸ್ ಸಮ್ ಅದರ್ ಗ್ರೌಂಡ್, ಯಾವುದೇ ಬೇರೆ ಕಾರಣ ಇರುತ್ತೆ ನೀವು ಲಿಮಿಟೇಷನ್ ಕ್ಲೇಮ್ ಮಾಡೋಕ್ಕೆ, ಇದು ಎಕ್ಸೆಂಪ್ಷನ್ ಕ್ಲೇಮ್ ಮಾಡೋಕ್ಕೆ. ಸೊ ಅದಕ್ಕೆ ಯಾವ ಗ್ರೌಂಡಲ್ಲಿ ಕೇಳಬೇಕು ಅಂತ ಹೇಳಿದಾಗ ಪ್ಲೇಂಟಲ್ಲಿ ಹೇಳಿರೋ ಗ್ರೌಂಡೇ ಅದಕ್ಕೆ ಆಧಾರ ಇರಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಆದರೆ ನೀವು ಏನು ಆಧಾರ ಹೇಳ್ತಿದ್ದೀರಾ ಈ ಕೋರ್ಟಲ್ಲಿ ಹೇಳಿರೋ ಆಧಾರದ ವಿರುದ್ಧವಾಗಿ ಇರಬಾರ್ದು. ಸೊ ದಟ್ ಗ್ರೌಂಡ್ ಶುಡ್ ನಾಟ್ ಬಿ ಇನ್ಕನ್ಸಿಸ್ಟೆಂಟ್ ವಿತ್ ದ ಗ್ರೌಂಡ್ ವಿಚ್ ಇಸ್ ಸೆಟ್ ಔಟ್ ಇನ್ ದ ಪ್ಲೇಂಟ್. So whatever grounds you have given in the plaint for your cause of action or for filing the suit, that is one ground, okay, and the why you have not filed during that period of limitation is some other ground, some other reason. So you can state that reason also. This proviso has been added to clear the doubts. Then the last one is rule 7 and 8, that is reliefs which are claimed. Now here there is a question. See, reliefs have to be claimed specifically, and we also said that if you ask for reliefs, suppose there are several grounds on which reliefs are claimed. Suppose you ask one relief, can you claim some other relief also? That is one thing. Then you are filing on several causes of action, so on separate and distinct grounds. You can join those causes of action, as we said. According to order 6, we can join all the causes of action. So in that case, what are the things relating to the several causes of action? So ಒಂದು ಸೂಟ್ ಫೈಲ್ ಮಾಡಬೇಕಾದ್ರೆ ಆ ಪ್ಲೇಂಟಲ್ಲಿ ನೀವು ಸುಮಾರು ರಿಲೀಫ್ಸ್ ಕೇಳ್ಬೋದು. ಒಂದು ರಿಲೀಫ್ ಕೇಳುವಾಗ ಇನ್ನೊಂದು ಬೇರೆ ರಿಲೀಫು ನಿಮಗೆ ಸಿಗ್ಬೋದು, ಅಥವಾ ಒಂದು ತಗೊಂಡಿದ್ರೆ ಒಂದು ರಿಲೀಫ್, ಒಂದು ಪರಿಹಾರ ಕೊಟ್ಟರೆ ಇನ್ನೊಂದು ಪರಿಹಾರ ಸಿಗದೇ ಇರ್ಬೋದು. ಆವಾಗ ಆಲ್ಟರ್ನೇಟಿವ್ ಅದಕ್ಕೆ ಒಂದು ಆಧಾರ ಕೇಳಿ, ಆ ಆಧಾರದ ಮೇಲೆ ನಾನು ಒಂದು ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಕೇಳಿ, ಅದಕ್ಕೆ ಬದಲಾಗಿ ಆಲ್ಟರ್ನೇಟಿವ್ ಆಗಿ ಇನ್ನೊಂದು ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಇದು ಕೊಟ್ಟಿಲ್ಲ ಅಂದರೆ ಇದು ಕೊಡಿ ಅಂತ ಕೇಳ್ಬೋದು. ಸೊ ಬೇರೆ ಬೇರೆ ಕ್ಲೇಮ್ಸ್ ಇದ್ರೆ ಅಥವಾ ಕಾಸಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ನ ಜಾಯಿನ್ ಮಾಡಿದರೆ, ಬೇರೆ ಬೇರೆ ವ್ಯಾಜ್ಯದ ಕಾರಣನ ಸೇರ್ಪಡೆ ಮಾಡಿ ಇದನ್ನು ಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದಿದ್ರೆ, ಆವಾಗ ಸೇಪ್ರೇಟ್ ಡಿಸ್ಟಿಂಕ್ಟ್ ಗ್ರೌಂಡ್ಸ್ ಇದ್ದರೆ ಆ ಪ್ರತ್ಯೇಕ ಗ್ರೌಂಡ್ ಸೇಪ್ರೇಟ್ಲಿ ಡಿಸ್ಟಿಂಕ್ಟ್ಲಿ ಹೇಳಬೇಕು. ಪ್ರತ್ಯೇಕ ಆಧಾರ, ನಿಮ್ಮ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್ ಯಾವ ಆಧಾರದ ಮೇಲೆ ನಿಂತಿದೆ, ಆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್, ಆ ವ್ಯಾಜ್ಯದ ಕಾರಣದ ಪ್ರತ್ಯೇಕ ಗ್ರೌಂಡ್ ಏನಿದೆ ಅದನ್ನು ಡಿಸ್ಟಿಂಕ್ಟ್ ಆಗಿ, ಸೇಪ್ರೇಟ್, ಬೇರೆ ಬೇರೆಯಾಗಿ, ಸ್ಪಷ್ಟವಾಗಿ, ಭಿನ್ನವಾಗಿ ಹೇಳಬೇಕು. Now, when we ask for a relief, there are several other things which the court will give. It is not that the court will stop there. Suppose the court thinks that he should be given some more reliefs, or he should be given some other reliefs also. The court has the power to decide and give him the relief. See, as I said in the beginning when we were discussing about the jurisdiction, suppose he asks for some certain amount of money, the court need not give him only that amount of money. The court can give him even more, even if it is beyond this, the filing jurisdiction which you have filed on the basis of the pecuniary jurisdiction. The amount which is granted may be more than that. Okay, that doesn't decide the jurisdiction. Jurisdiction is decided by the amount of the value of your suit. So suppose you ask something and the court gives more reliefs. So you need not specifically state that the other reliefs or whatever other reliefs the court thinks just should be given. Of course, there is a custom, or there is a what you call as a convention, that we say that as I pray for all other reliefs as the court may think just and equitable in the interest of justice and equity anta baritivi. But it is not mandatory to write that. Even it is not necessary to ask for any general relief or any other relief. What you have to ask is, it shall specifically state the relief. First, number 1. Rule 7 says specifically, ನಿರ್ದಿಷ್ಟವಾಗಿ ಆ ಪರಿಹಾರನ ಹೇಳಬೇಕು. ಯಾವ ಪರಿಹಾರ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಯಾವ ರೈಟ್ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಆನ್ ವಾಟ್ ರೈಟ್ ವಿ ಆರ್ ಕ್ಲೇಮಿಂಗ್ ದ ರಿಲೀಫ್, ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ವೆರಿ ಕ್ಲಿಯರ್ಲಿ. It must be either simple relief, only one relief, or you can ask for an alternative relief also. Both the reliefs you can ask in alternative. It is allowed. ಅದನ್ನ ಬರೀಬಹುದು. ಸೊ ಪರ್ಯಾಯವಾಗಿ ಇದನ್ನ ಕೊಡಿ, ಇದನ್ನ ನಾನು ರಿಲೀಫ್ ಅಂತ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಕೋರ್ಟ್ ಪರ್ಯಾಯವಾಗಿ ಇದನ್ನ ಕೊಡಬಹುದು ಅಂತ ಎರಡೂ ಹೇಳ್ಬೋದು. ಸೊ ಇಟ್ ಡಸಂಟ್ ಮೀನ್ ದಟ್ ಯು ಆರ್ ಲೀವಿಂಗ್ ಔಟ್ ಸಮಥಿಂಗ್. ದೆನ್ several distinct claims idre, if there are several distinct claims on different causes of action, you have to state each cause of action and those reliefs separately and distinctly. So this is one thing. Now there comes a question that after the institution of the suit, after the suit has been instituted, some other things happen. There are several events which are happening, and because of that the plaintiff's rights may give him more reliefs. Some other rights may arise, or some other cause of action may arise later on after the suit is filed. So whether that can be considered by the court is a question. Now the case is pending, okay, and we all our thing is that we should not file a suit leaving out any of the reliefs. Okay, that can be according to the day of filing of the suit. But if something happens later, then do we have to file a separate suit for that? This is pending relating to the same subject matter, and relating to the same subject matter some other events take place. Then whether that changed circumstances can be considered by the court. Now the basic rule, ಈಗ ಏನಾಗುತ್ತೆ ಅಂದರೆ, ಒಂದು ಕೇಸ್ ಫೈಲ್ ಮಾಡಿದಾಗ ನಂತರ ಕೆಲವು ಪ್ರಸಂಗಗಳು ಆಗುತ್ತೆ, ಕೆಲವು ಸಂದರ್ಭಗಳು ಆಗುತ್ತೆ. ಅದರಿಂದ ಅವನಿಗೆ ಏನು ಬೇಕಾಗಿದೆ ಅದನ್ನು ಕೇಳುವಾಗ ಅದ್ರ ಜೊತೆಲೆ ಬೇರೆ ಕಾಸಸ್ ಆಫ್ ಆಕ್ಷನ್ ಸೇರ್ಕೊಳ್ಳುತ್ತೆ, ವ್ಯಾಜ್ಯದ ಕಾರಣಗಳು ಸೇರ್ಕೊಳ್ಳುತ್ತೆ. ಅದೇ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್, ವಿಷಯ ವಸ್ತುವಿಗೆ ಸಂಬಂಧಪಟ್ಟಿರುವಂಥ ಅವನು ಬೇರೆ ರಿಲೀಫ್ಸು ಕೇಳಬಹುದು. ಆದರೆ ಈಗ ಆಲ್ರೆಡಿ ಒಂದು ರಿಲೀಫ್ ಕೇಳಿಬಿಟ್ಟಿದ್ದಾನೆ. ಬೆಸ್ಟ್ ಎಕ್ಸಾಂಪಲ್ ವಿ ಕ್ಯಾನ್ ಸೇ ಇಸ್ ರಿಲೇಟಿಂಗ್ ಟು ಮೇಂಟೆನೆನ್ಸ್ ಆಲ್ಸೋ. A person who files for maintenance, the maintenance will be arising every month, so it will be continuation. So you can ask for the total maintenance which has to be paid of this amount anta helbodu, athwa it can be consequent also. But even then, even if it is a relating to possession, ಪೊಸೆಷನ್ಗೆ ನೀವು ಕೇಳ್ತೀರಾ, ಅಥವಾ ನೀವು ಟೈಟಲ್ ಮೇಲೆ ನೀವು ನನಗೆ ಡಿಕ್ಲೇರ್ ಮಾಡಿ, ನಾನು ಓನರ್ ಆಗಿದ್ದೀನಿ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಪ್ಲೇಂಟಿಫ್ ಕೇಸ್ ಹಾಕ್ತಾನೆ. ಇದನ್ನ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಹೇಳುವಾಗ ಮಧ್ಯದಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಅವನು ಇಂಜೆಕ್ಷನ್ಗೂ ಹಾಕಿರ್ತಾನೆ, ಒಂದು ಕೊಡಿ, ತಡೆ ಆಜ್ಞೆ ಕೊಡಿ, ಅವನು ನನ್ನ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಸೇರ್ಕೊಳ್ಳೋಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, ಪ್ರಯತ್ನ ಪಡ್ತಾ ಇದ್ದಾನೆ. ಸೊ ಸಪೋಸ್ ಹಿ ಸೂಟ್ಸ್ ಫಾರ್ ದ ಇಂಜಂಕ್ಷನ್ and he says that the person is trying to get into the possession of my property, he is trying to interfere in my peaceful possession, and therefore give an order. I pray for an order that the court should stop him from doing these things. You have filed a suit for that. Now the plaintiff, when he files that suit, in the meantime what happens, subsequent to filing of the suit, when it is pending, the plaintiff manages, the defendant manages to get into the property and take the possession. Now what happens, should he file another suit for that purpose? Can that be taken into consideration by the court? ಈಗ ಅವನು ಮಧ್ಯೆ ಸೇರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾನೆ, ಆವಾಗ ಆ ಪೆಂಡಿಂಗ್ ಇರುವಾಗ ಅವನು ಅದನ್ನ ಸ್ವಾಧೀನತೆ ತಗೊಂಡ್ಬಿಟ್ರೆ ಅದನ್ನ ಆ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ನ ಕೋರ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದಾ? ಸೊ ಈ ಪ್ರಶ್ನೆ ಇದ್ದಾಗ ರಿಲೀಫ್ ಚೇಂಜ್ ಆಗುತ್ತೆ. ಈಗ 7 and 8 ಅಲ್ಲಿ ನಾವು ಏನು ಹೇಳಿದ್ವಿ, ರೂಲ್ 7 and ರೂಲ್ 8, that it should be clear, the cause of action should be clear, and we have to speak about what are the things which arise out of the cause of action. ಆ cause of action ಎಂದೇ ಏನೇನು ಬರಬೇಕು ಅದನ್ನು ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಬೇಕು. ಸೊ when we say that this has to be asked in reliefs, when things happen later. So basic rule is that rights of the party should be determined at the date of filing of the suit. That is the basic rule. ಒಂದು ಬೇಸಿಕ್ ನಿಯಮ ಏನಿದೆ ಅಂದ್ರೆ, ಮೂಲಭೂತ ನಿಯಮ ಏನು, ಆ ಸೂಟ್ ಫೈಲ್ ಮಾಡೋ ಸಮಯದಲ್ಲಿ ಅವನ ರೈಟ್ಸ್ ಏನಿದೆ ಅದ್ರ ಪ್ರಕಾರ ಅವನು ಕೇಳಬೇಕು, ಅದನ್ನ ಮಾತ್ರ ಗಮನಕ್ಕೆ ತಗೊಳುತ್ತೆ. ಅದರಿಂದ ನಂತರ ಏನು ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅರೈಸ್ ಆಗುತ್ತೆ, ನಂತರ ಏನು ಬೇರೆ ವ್ಯಾಜ್ಯದ ಕಾರಣಗಳು ಉಂಟಾಗುತ್ತೆ, ಅದಕ್ಕೆ ಅವನು ಕೇಳಕ್ಕಾಗಲ್ಲ ಅಥವಾ ಅದು ಅವನು ಇವ್ರನ್ನ ಈ ರಿಲೀಫ್ಸ್ ಅಲ್ಲಿ ಸೇರ್ಸಕ್ಕಾಗಲ್ಲ ಅಂತ ಒಂದು ಬೇಸಿಕ್ ರೂಲ್. ಯಾಕೆಂದ್ರೆ ಇಟ್ ಮೇ ಗೋ ಆನ್ ಆಡಿಂಗ್ ಟು ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್. When the suit is filed, there are number of things which are happening, and there are number of things which come into force, or there may be some changes. Then if we go on changing, of course you may ask for amendment. Amendment of plaint kelbodu on the basis of something which I could not ask at the time of filing of the suit, so I need to amend my claim anta amendment to agbodu. But again, amendment can be allowed based on the different things which we have spoken in the last class. That is the matter in controversy between these two has to be decided. It should not cause injustice to the other side, that is there. But there are some things which you may not be asking as an amendment also, but it is a duty of the court to consider. So in appropriate cases, it is not only the power but the duty of the court to consider the changed circumstances. This thing was given as a order in one case, that is Amarjit Singh versus Khatun Komarine. Just for a reference, in All India Reporter 1987, I am referring to this case, wherein the court said that subsequent events can be taken cognizance of if they are relevant or material. ಇದನ್ನ ಹೇಳಿದ್ದಾರೆ. ಈ ಕೇಸಲ್ಲಿ ಏನು ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ, ನಂತರ ಈ ಕೇಸ್ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ ಮೇಲೆ ಯಾವುದಾದ್ರೂ ಬೇರೆ ಇದನ್ನ ಆದರೆ, ಯಾವುದಾದ್ರೂ ಬೇರೆ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಬಂದರೆ ಅಥವಾ ಬೇರೆ ಪ್ರಸಂಗಗಳು ಘಟಿತ ಆಗಿದ್ರೆ, ಬೇರೆ ಘಟನೆಗಳಾಗಿದ್ರೆ, ಆವಾಗ ಅದು ರೆಲೆವೆಂಟ್ ಇದೆಯಾ ಅಂತ ನೋಡಬೇಕು, ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿರುವಂಥದ್ದು ಇರಬೇಕು. ಎರಡನೇದಾಗಿ ಮೆಟೀರಿಯಲ್ ಇರಬೇಕು. ಇದನ್ನ ಮುಖ್ಯವಾಗಿ ಅದನ್ನ ಗಮನಕ್ಕೆ ತಗೊಳ್ಳಕ್ಕೆ ಅವಶ್ಯಕ ಇರಬೇಕು. Only such events can be taken cognizance of which are relevant or which are material. Okay, now continuing that, we can give some illustrations. See, what are the things which happen after institution of a suit? See, during pendency of a suit for permanent injunction, as I said just now, there is a suit for permanent injunction, and in the meantime the plaintiff obtains possession, the defendant obtains possession and the plaintiff is dispossessed. Then see, it is for only permanent injunction. ಇವನು ಫೈಲ್ ಮಾಡಿರೋದು ತಡೆಯಾಜ್ಞೆಗೋಸ್ಕರ, ಆದರೆ ಸ್ವಾಧೀನತೆ ತಗೊಂಡಿದ್ದಾನೆ. ಆವಾಗ ಅದ್ರ ಜೊತೆಲೆ ತಡೆಯಾಜ್ಞೆ ಕೊಟ್ಟು ರಿಸ್ಟೋರೇಷನ್ ಆಫ್ ಪೊಸೆಷನ್ ಕೇಳಬಹುದು. ಆ ರಿಲೀಫು ಕೋರ್ಟ್ ಕೊಡಬಹುದು. ಇಫ್ ಯು ಬ್ರಿಂಗ್ ದಟ್ ಫ್ಯಾಕ್ಟ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಟೇಕ್ ನೋಟಿಸ್ ಆಫ್ ದಟ್ ಫ್ಯಾಕ್ಟ್ ಅಂಡ್ ಗ್ರಾಂಟ್ ರಿಲೀಫ್ ಫಾರ್ ರಿಸ್ಟೋರೇಷನ್ ಆಫ್ ಪೊಸೆಷನ್ ಆಲ್ಸೋ ಆಫ್ ದಟ್ ಕೇಸ್, ಆಫ್ ದಟ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆರ್ ದಟ್ ಪ್ರಾಪರ್ಟಿ. Now the second illustration we will discuss is about partition. See, when a partition is instituted, partition suit is instituted, the person who asks for partition adds all his brothers or sisters or whoever are entitled to that particular property as defendants. Okay, now there is a partition suit by A against his two brothers B and C. Among that, C dies during the pendency of the suit. C dies. So now, when there are two brothers B and C, he asks 1/3 share. Okay, because two brothers and myself, there are 3, so I ask for 1/3 share. Now when one person dies and he does not, let us assume that he does not have anybody who claims under him, so then there are only 2 people. So this change which happens after the institution of the suit, he can claim 1/2 share instead of 1/3. You cannot say that he has already asked for 1/3 share, so he will get only 1/3 share. The relief has already been stated. So the court can take into consideration, because that is a material fact. ಸೊ ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಕೇಳುವಾಗ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಅದರಲ್ಲಿ ಮೃತ್ಯು ಆಯಿತು ಅಂತ ಹೇಳಿದರೆ, ಅವನಿಗೆ ಯಾರು ಇಲ್ಲ ಅಂತ ನಾವು ಪ್ರಿಸರ್ವ್ ಮಾಡಿದರೆ, ಆವಾಗ ಈ ಇಬ್ಬರೇ ಇರೋದ್ರಿಂದ 1/3 ಏನು ಕೇಳ್ತಾ ಇದ್ದ, 3ನೇ ಭಾಗ ಕೇಳ್ತಾ ಇರೋದನ್ನು ಅವನು ಅರ್ಧ ಭಾಗನ ಕ್ಲೇಮ್ ಮಾಡಬಹುದು. ಸೊ ರಿಲೀಫ್ ಚೇಂಜ್ ಆಗುತ್ತೆ. ಅಲ್ಲಿ ಅವನ ಎಷ್ಟು ಅಮೌಂಟ್ ಹೇಳಿರ್ತಾನೆ ಆ ಅಮೌಂಟು ಚೇಂಜ್ ಆಗಿರುತ್ತೆ, ಅಥವಾ ಆ ಪಾಯಿಂಟ್ ಆ ವಿಭಾಗಣೆ ಪ್ರಕಾರ ಅವನ ಬೇರೆ ವಿಭಾಗಣೆ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಅದನ್ನು ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ ತಗೋಬಹುದು. ಮೂರನೇದಾಗಿ ಒಂದು ಪ್ರೊಸೀಡಿಂಗ್ ಅಂಡರ್ ದ ರೆಂಟ್ ಕಂಟ್ರೋಲ್ ಆಕ್ಟ್ ಇದೆ ಅಂತ ಅನ್ಕೊಳ್ಳೋಣ. ದರ್ ಇಸ್ ಅ ಪ್ರೊಸೀಡಿಂಗ್ ಅಂಡರ್ ದ ರೆಂಟ್ ಕಂಟ್ರೋಲ್ ಆಕ್ಟ್. ಇದರಲ್ಲಿ ಕಾರಣಗಳು ಇರುತ್ತೆ. ರೆಂಟ್ ಕಂಟ್ರೋಲ್ ಆಕ್ಟ್ ಪ್ರಕಾರ ಯಾವ ಕಾರಣಕ್ಕೆ ನೀವು ಅದನ್ನ ವಾಪಸ್ ಪಡ್ಕೋತಾ ಇದ್ದೀರಾ, ಈಗ ಟೆನೆಂಟನ್ನ ಬಾಡಿಗೆದಾರನ್ನ ಎವಿಕ್ಟ್ ಮಾಡಬೇಕಾದ್ರೆ, ಆಚೆ ತಳ್ಳಬೇಕಾದ್ರೆ ಅವನಿಗೆ ಬೇಡ ನಾವೇ ಅಲ್ಲಿ ಇರಬೇಕು ಅಂತ ಹೇಳ್ಬೋದು, ಅಥವಾ ಬೇರೆ ಕಾರಣಗಳು ಇಡಬಹುದು. ಟೆನೆಂಟ್ ಸರಿಯಾಗಿ ನೋಡ್ತಾ ಇಲ್ಲ, ಅವನು ಸರಿಯಾಗಿ ನನ್ನ ಪ್ರಾಪರ್ಟಿಯನ್ನ ದುರಸ್ತಿ ಮಾಡ್ತಾ ಇಲ್ಲ, ಎನಿ ಗ್ರೌಂಡ್ಸ್ ವಿಚ್ ಆರ್ ಸ್ಟೇಟೆಡ್ ಇನ್ ದ ರೆಂಟ್ ಕಂಟ್ರೋಲ್ ಆಕ್ಟ್. So there is a proceeding going on. It is pending for permission to evict a tenant. Okay, he wants to evict a tenant. ಈಗ ಏನಾಗುತ್ತೆ, ಸಬ್ಸಿಕ್ವೆಂಟ್ ಈವೆಂಟ್ಸ್ ಆಗುತ್ತೆ, ಅದರಲ್ಲಿ ಸುಮಾರು ಈವೆಂಟ್ಸ್ ಆಗುತ್ತೆ. ಅದರಿಂದ ಆ ರೈಟ್ ಆಫ್ ದ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಏನಿದೆ ಟು ಎವಿಕ್ಟ್ ಅ ಟೆನೆಂಟ್, ಇಟ್ ಚೇಂಜಸ್. ಬೇರೆ ಕಾರಣಗಳು ಆಗಿರೋದ್ರಿಂದ ಈಗ ಆ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ಗೆ ಏನೇನೋ ರೈಟ್ಸ್ ಇದೆ, ಆ ರೈಟ್ಸ್ ಡಿಫರೆನ್ಸ್ ಆಗಬಹುದು. See, for example, he may cause more damage, or he may bring somebody as a subtenant. ಟೆನೆಂಟ್ ಯಾರಿಗೂ ಇದು ಈ ಗ್ರೌಂಡ್ಸು ಬಂದ್ಬಿಡ್ತು ಅದ್ರ ಜೊತೆಲೆ. ಸೊ ಒಂದು ಗ್ರೌಂಡ್ ಮಾತ್ರ ನೀವು ಹೇಳಿದ್ರಿ, ನನಗೆ ಬೇಕಾಗಿದೆ, ನಾನು ಅಲ್ಲಿ ಸ್ವಂತ ಕಾರ್ಯ ಮಾಡಬೇಕು ಅಥವಾ ನಾನು ಇರಬೇಕು ಅಂತ ಹೇಳಿ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತ. ಬೇರೆ ಗ್ರೌಂಡ್ಸ್ ಆಗುತ್ತೆ, ಅವನು ಬೇರೆ ಬೇರೆ ಘಟನೆಗಳಾಗುತ್ತೆ. ಈ ಗ್ರೌಂಡ್ಸ್ ಸೇರಿಸಿದ್ರೆ ಅವನಿಗೆ ಮತ್ತೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಈವೆಂಟ್ಸ್ ಇಂದ ಪರಿಹಾರಗಳು ಬೇರೆ ಆಗುತ್ತೆ, ಬೇರೆ ಅವನಿಗೆ ಸಿಗ್ಬೋದು. ಎವಿಕ್ಷನ್ ಆಫ್ ಟೆನೆಂಟ್ ತಗೊಳಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ ಗ್ರೌಂಡ್ಸ್ ಆಗ್ಬಹುದು. So these subsequent events affecting the rights of the landlord to evict can be taken into account after the institution of the suit also. It is not that filing of the suit time ಅಲ್ಲಿ ಏನಿತ್ತು ಅದನ್ನ ಮಾತ್ರ ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ಅಂತ ಕೋರ್ಟ್ ಹೇಳಕ್ಕಾಗಲ್ಲ. Then there is one case, Mahalinga Tambiran versus Arul Nandi Tambiran, All India Reporter 1974, Supreme Court 199, page number 199. This is a landmark case because it is a All India Reporter, it is 1974. Okay, then pending the appeal in the Supreme Court, what has happened is the defendant was the head of the mutt, and the plaintiff who files this case, he was declared as a successor of the defendant under a will. Will prakara avanu declare agirtane. So the will comes into force after the death of a person, right? Now what happens, the mutt, head of the mutt, nominates somebody else as a successor, and then he files a case not on the basis of the will but on the basis that he was nominated earlier and he needs to be the head of the mutt. So he needs to be the successor anta heli file madidane. So when it is an appeal in the Supreme Court, okay, ee appeal na pending iruvaga aa defendant enirtane head of the mutt avanu ಮೃತ್ಯು ಆಗುತ್ತೆ. ಸೊ ಆವಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನು ನೋಟಿಸ್ ತಗೊಳುತ್ತಂದ್ರೆ, ಸಿ ದ ವಿಲ್ ಇಸ್ ದೇರ್, ಆ ವಿಲ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಅವನು ಡಿಕ್ಲೇರ್ ಮಾಡಿರ್ತಾರೆ ಪ್ಲೇಂಟಿಫ್ನ successor of the defendant, and already it is declared, and that will comes into force after his death. So his death takes place when the pending of the suit is there. So the other events which he has stated, that does not have any importance at all, because under the will he is a successor. So the Supreme Court just looks into that, and that he has nominated the plaintiff as his successor in the will, and therefore though the deceased defendant had revoked, alleged to have been revoked, it is not proved before the court that it is revoked. Of course, if it is proved, then the last will prevail. But the will is there, which is the last will. At the death of a person, the last will prevail, whether there is a will or not. Otherwise, it has to be revoked in a proper manner. So that has not been proved, so he is declared as a successor. See, this happens because he dies during the pendency of the suit. So this is important, that the events which are happening even after institution of the suit can be taken into consideration by the court when the court decides some matter. So this relief, when we ask, we have to look into this. But when sometimes subsequent events will not be considered also. See, where the rights of the parties have already crystallized, ಕೆಲವು ಸತೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಈವೆಂಟ್ಸ್ ಇಂದ ಅದನ್ನ ತಗೊಳಕ್ಕಾಗಲ್ಲ, ಅದನ್ನ ಗಮನಕ್ಕೆ ಇಟ್ಕೊಳಕ್ಕಾಗಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಆ ಪೆಂಡಿಂಗ್ ಇರುವಾಗ ಆ ಪಾರ್ಟೀಸ್ ಅವರ ಹಕ್ಕುಗಳನ್ನ ಒಂದು ಸ್ಥಾನ ಬಂದಿರುತ್ತೆ, ಫೈನಾಲಿಟಿ ಬಂದಿರುತ್ತೆ, ಒಂದು ಕೊನೆ ಆಗಿರುತ್ತೆ. ಡಿಸಿಷನ್ ಹ್ಯಾಸ್ ರೀಚ್ಡ್ ಫೈನಾಲಿಟಿ. Already the court has given decision relating to some matter, maybe pending the suit itself it has decided some matter. then that concluded controversy cannot be reopened on the basis of subsequent events. This is the case Bhajan Lal versus State of Punjab, 1971. First volume, Supreme Court cases, page number 34. In this case, the basis of subsequent events by divesting a party of the benefit of the right which accrued to him is not possible, because a person asks for a relief, that relief is given by the court, and after giving the relief, that person gets that right. So he gets that right in law. ಕಾನೂನು ಪ್ರಕಾರ ಅವನಿಗೆ ಒಂದು ಹಕ್ಕು ಬಂದ್ಬಿಡ್ತು, ಯಾಕಂದ್ರೆ ಕೋರ್ಟ್ ಆ ರೈಟ್ ಕೊಡ್ತು ಅವನಿಗೆ. ಸೊ ದಟ್ ರೈಟ್ ಇಸ್ ಅಕ್ರೂಡ್ ಟು ಹಿಮ್. Now, because something else happens later on, subsequent events have happened, he goes in appeal and says that subsequent events have happened and now I need to come in appeal on that ground and divest him of his right. That cannot happen, because divesting a person of a right which already has accrued, for that purpose subsequent events will not be considered in that case, and that case will not be reopened on that ground. You understand? So once the right is final, once the right is crystallized, once the right is decided by the court, it becomes final, and then you cannot question it between the same parties. We know that. So that is why subsequent events will not be considered in such a case. Now the last point which we will discuss today is admission of the plaint. Now the admission of the plaint will be done as soon as we know the procedure of filing, institution of suit. The plaint will be filed in the court, and the registrar will look into it. Then it will be numbered, all those things which we discussed about the procedure of filing the plaint. Once it is filed, the plaint is admitted by the court. When it is admitted by the court will direct the plaintiff to present as many copies of the plaint on plain paper as there are defendants. Suppose there are 2 or more defendants, then the court will ask the plaintiff to present, suppose there are 2 or 3 defendants, or there are 4 defendants, 4 copies of the plaints have to be presented. 2 copies of the plaint have to be presented along with the plaint. Why? Because once the summons is sent to that particular defendant, he has to know what is the case which he has to represent or which he has to face, and therefore he needs to know the details. So the copy has to be served upon him. For that purpose, the court will direct the plaintiff to present as many copies. The normal procedure is that at the time of filing, we file the copies of the plaint, as many copies of the plaint as there are defendants before the court. Why we say plain paper? Because there is a prescribed paper for the plaint. Okay, there is a prescribed green sheets, and there are according to the rules of the court, again there are rules of civil practice. The requirement of the sheets and the paragraphs and everything is stated. So besides that, the copies can be presented on plain paper, ordinary paper, and that will be within 7 days from the date of the order that has to be presented, and within 7 days from the date of the order, requisite fee should be paid for the service of summons on the defendant. Now how many defendants are there? To serve summons upon these defendants, the court will ask for the amount, that is the required fees to be paid by the plaintiff in the court. If these things are not done, suppose he does not file the copies, or if he does not give the or pay the requisite fees within 7 days from the date of such order, then the plaint is liable to be rejected. It can be rejected by the court on that ground itself. So that is why it is important. Admission of the plaint, Rule 9 says that at the time of filing, once it is admitted, the direction will be to the plaintiff to present it. Okay, and then after this is done, it is deemed that the plaint has to be filed. The next things which has to be discussed with are 2 important things, that is a return of the plaint and rejection of the plaint. So what are the grounds when the plaint can be returned to the plaintiff, on what grounds it can be returned to the plaintiff, and what grounds it can be rejected? There are 2 things which we will be discussing in detail in the next class, because there are certain grounds on which it has to be rejected. Then what is the procedure, and what are the effects of return of the plaint, what are the effects of return or rejection of the plaint? That has to be discussed under Rule 10, 10A, 10B, and Rule 11. So these are the details which we will be discussing in the next class. So today we have seen that the whole procedure of filing the plaint before the court is, of course we have described about the procedure, and is that the particulars of the plaint which has to be entered is mandatory. If any particular is left out, if any particular which he knew at the time of filing the plaint has not been set before the court, then what happens? He may not be allowed to lead evidence on that particular matter which he has not pleaded in the plaints. Therefore, drafting of a plaint is very, very important, and it has to be carefully drafted, and all the matters which he seeks, whether it is a money suit, whether it is a suit for declaration, whether it is a suit for possession of a property, where there is a subject matter is immobile property, where subject matter is immovable property, what are the rights which he claims and what are the reliefs which he has, all those things have to be brought together. If he leaves out anything, any claim, any relief, then he will be precluded from asking those reliefs later on. So plaint ಫೈಲ್ ಮಾಡಬೇಕಾದ್ರೆ ತುಂಬ ಕಾಳಜಿಯಿಂದ, ನಿರ್ಲಕ್ಷ್ಯತೆ ಇಲ್ಲದೆ ಎಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸನ್ನು, ಎಲ್ಲ ಮಾತುಗಳನ್ನು ಸರಿಯಾಗಿ ಪರ್ಟಿಕ್ಯುಲರ್ಸನ್ನು ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ವೈಸ್ ಅದನ್ನು ಹೇಳಬೇಕು, ಅದನ್ನು ಬರಿಬೇಕು. ಮತ್ತು ಯಾವ್ಯಾವ ಮ್ಯಾಟರ್ ಇಸ್ ಪ್ರೊಸೀಜರ್ ನಾವು ಪ್ಲೀಡಿಂಗ್ಸ್ ಆರ್ಡರ್ 6 ಅಲ್ಲಿ ನೋಡಿದ್ವಿ. ಸೊ ಆರ್ಡರ್ 6 and ಆರ್ಡರ್ 7 ರಿಲೇಟಿಂಗ್ ಟು ಪ್ಲೀಡಿಂಗ್ಸ್, ಆರ್ಡರ್ 6 ರಿಲೇಟಿಂಗ್ ಟು ಪ್ಲೀಡಿಂಗ್ಸ್, ಆರ್ಡರ್ 7 ರಿಲೇಟಿಂಗ್ ಟು ಪ್ಲೇಂಟ್, order 8 we will come to relating to written statement. All that has to be kept in mind when we are drafting the documents. So drafting is a very important thing when we come to commencement of a suit before the court. So with this note I would end this. Anybody who wants to ask any question can post your questions. Any questions are there relating to the plaint, and what are the things, relating to any relief which is asked later on, or any other thing which is a part of this study. You can come forward with your questions, and you can ask me any questions. If there are any questions, we will continue, or we will proceed to the next discussion in the next class. Thank you very much.